Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or psychological advice. Divorce laws, filing requirements, and financial implications vary significantly by state and individual jurisdiction. While we explore the utility of online educational platforms often referred to as divorce universities, these resources are tools for literacy and preparation, not a substitute for the counsel of a licensed attorney or certified financial planner. You should always conduct your own due diligence and consult with qualified professionals regarding your specific situation before making any life-altering decisions. Imagine standing in a room where every word you speak costs you $7. Every time you ask a question, a clock ticks and a bill grows. For decades, this has been the standard reality for millions of Americans navigating the end of a marriage. We have been conditioned to believe that the only path through the dissolution of a domestic partnership is a high-stakes, adversarial battleground where the only winners are the ones billing by the hour. But a quiet revolution is currently being captured by modern U.S. documentaries, revealing a shift that is terrifying the traditional legal establishment. We are seeing the rise of the divorce university. This is not a physical campus with ivy-covered walls, but a digital infrastructure designed to dismantle the information asymmetry that has kept the American public in a cycle of litigation and debt. Recent investigative pieces have highlighted a shocking statistic. The average litigated divorce in the United States can range from $15,000 to over $30,000 per person. When you factor in the emotional tax and the potential for multi-year delays, the cost becomes astronomical. The open loop we are stepping into today is simple. Why are some of the most successful high-net-worth individuals, as well as savvy middle-class families, suddenly turning away from traditional law firms and toward structured, online educational curricula to end their marriages? Documentaries are now portraying these online universities not just as a budget alternative, but as a superior method for maintaining agency and psychological health. In this deep dive masterclass, we are going to explore the mechanics of these platforms and why the U.S. documentary circuit is suddenly obsessed with the utility of digital legal literacy. We are solving a specific, high-stakes problem for you today: how to navigate one of life's most complex transitions without losing your financial future or your sanity to a system that was never designed for your efficiency. To understand the utility of these online platforms, we must first look at the historical trends that created the necessity for them. Since the introduction of no-fault divorce laws in the 1970s, the U.S. legal system has struggled to keep pace with the sheer volume of cases. This has created what sociologists call legal deserts, where access to affordable representation is nearly non-existent. Documentaries focusing on judicial reform have pointed out that a significant percentage of people in the family court system are now appearing pro se, meaning they are representing themselves. However, representing yourself without a map is like trying to fly a plane because you once sat in coach. This is where the divorce university fills the gap. These platforms function as a comprehensive masterclass in procedural law, financial auditing, and mediation strategy. Let's look at the data surrounding historical trends in the American legal industry. For years, the barrier to entry for legal knowledge was the mahogany door of a law office. You paid for access to forms, for the understanding of filing deadlines, and for the interpretation of local statutes. Modern documentaries are now highlighting case studies of individuals who used online curricula to flip the script. Instead of walking into a lawyer's office with a shoebox full of disorganized receipts and a heart full of resentment, these individuals are entering the process as educated consumers. They have already completed modules on asset division, they understand the difference between separate and marital property, and they have drafted their own parenting plans based on templates that have been vetted by historical case law. The utility here is not just about saving money, although the potential outcomes for your bank account are significant. It is about the redistribution of power. When you engage with a divorce university, you are essentially engaging in a deep dive simulation of your own case. You are learning the language of the court before you ever step foot in a courtroom. Investigative journalists have noted that when one or both parties are digitally literate in the divorce process, the time spent in active litigation tends to drop. This is because the education focuses on objective data rather than subjective emotion. These documentaries often contrast two paths: the traditional path, which is often fueled by the adrenaline of conflict, and the educated path, which is fueled by the clarity of a curriculum. Consider the step-by-step details of what these documentary-featured platforms actually provide. They start with an audit of the current landscape. Most users begin with a module on the jurisdictional specifics of their home state. In the US, divorce is not a federal matter. It is a patchwork of 50 different sets of rules. An online university provides a centralized, updated database that explains these nuances in plain English. For example, understanding the difference between an equitable distribution state and a community property state can change your entire financial strategy. A documentary might follow a protagonist in California who discovers through an online module that their inheritance, if kept separate, might not be subject to division. This single piece of information, gained through a $99 online course, could save them hundreds of thousands of dollars that might have otherwise been lost to a lack of preparation or a distracted attorney. Furthermore, these platforms offer modules on the psychological architecture of negotiation. This is a recurring theme in recent US media. The idea that divorce is 10% legal and 90% emotional and financial. By treating the process as a university-level subject, users can detach from the person they are divorcing and attach to the project of the dissolution. This shift in perspective is documented as a primary factor in reducing the long-term trauma associated with family restructuring. We see case studies where parents use these online tools to build co-parenting apps and communication protocols that bypass the need for a judge to intervene in their daily lives. The rise of the divorce university also speaks to a broader trend in American society: the democratization of professional knowledge. Just as WebMD changed how we interact with doctors, and E-Trade changed how we interact with brokers, these online platforms are changing how we interact with the Bar Association. Documentaries are portraying this as a necessary disruption of an industry that has remained largely unchanged for over a century. They highlight the utility of being able to pause, rewind, and rewatch a lecture on how to calculate child support according to state guidelines, rather than trying to digest that information in a frantic, billable meeting. As we move forward in this series, we will examine the specific documentaries that have brought this to light, the specific platforms that are leading the charge, and the step-by-step methods they teach for navigating everything from debt allocation to emotional resilience. We are looking at a future where the end of a marriage is seen not as a failure to be litigated, but as a transition to be managed through education. The promise of this masterclass is to show you exactly how that transition is being handled by those who choose to educate themselves, rather than just pay for representation. We are diving into the data, the case studies, and the historical shifts that make the divorce university the most potent tool in the modern American arsenal for domestic self-defense. Stay with us as we break down the infrastructure of this digital shift and what it means for the future of the American family. To understand why 2026 has become the year of the educated litigant, we have to look at the specific curriculum structures that U.S. documentaries are now showcasing as the gold standard for marital dissolution. These platforms, often branded as divorce universities, operate on a modular system that mirrors a high-level MBA program. They do not just hand you a stack of forms. They provide a comprehensive framework for what documentaries like The Digital Split are calling the professionalization of the personal life. In these films, we see a recurring theme: the shift from being a victim of the system to becoming a manager of the process. Consider the first major pillar of this utility, the financial forensic module. Historical trends in the U.S. legal system show that nearly 70% of divorce litigation delays are caused by incomplete or contested financial disclosures. Imagine if you were Sarah, a marketing executive in Columbus, Ohio, in early 2026. In a traditional scenario, Sarah would spend months and thousands of dollars in billable hours as her attorney sent repeated requests to her spouse's counsel for tax returns, bank statements, and investment records. A 2026 documentary might portray Sarah sitting at her laptop, utilizing a divorce university's automated discovery tool. This tool doesn't just ask for documents. It teaches her how to read a Schedule K-1, how to identify hidden offshore accounts using digital trail analysis, and how to value a small business based on current 2026 market multiples. The step-by-step detail portrayed in these documentaries is exhaustive. First, Sarah is taught the onboarding and jurisdiction audit. This is where she learns that while she lives in Ohio, the specific county she resides in might have local rules that differ from the neighboring county. The university provides a checklist of 22 specific financial documents that are required before she even thinks about filing. By the time Sarah actually speaks to a legal professional, she has already organized her digital life into a format that a forensic accountant would envy. This is what documentaries call the compression of the discovery phase. Instead of paying a paralegal $300 an hour to organize her files, she has done it herself as a student of the process. Next, we look at the case study of Marcus in Phoenix, Arizona. Marcus's story is a centerpiece in the 2026 investigative piece titled The Community Property Myth. In Arizona, a community property state, Marcus initially believed that every asset acquired during the marriage was a 50-50 split. However, through his enrollment in an online divorce university, Marcus discovered a module on the transmutation of assets. He learned the historical trends of how separate property, like his premarital inheritance, can accidentally become community property if it is commingled. The documentary follows Marcus as he uses the university's calculators to trace the flow of funds from his inheritance into the family's mortgage payments over a 10-year period. By learning the specific math of the Van Camp or Pereira formulas, complex methods for valuing business growth, Marcus was able to present a clear, data-driven argument to a mediator. The utility here is undeniable. Marcus didn't just guess his way through a negotiation. He used the university's pedagogical tools to build a financial fortress. Imagine if you had to negotiate the most important contract of your life, while your adrenaline was at its highest and your sleep was at its lowest. This is the problem the negotiation psychology module solves. Documentaries are now highlighting how these universities incorporate behavioral economics and high-conflict communication strategies. They teach the BIF method: brief, informative, friendly, and firm, as a standard for all digital communication. In 2026, where a single text message can be used as evidence in a custody hearing, this education is vital. Documentary footage often shows students practicing these communication styles in simulated environments. They are taught to respond to a provocative email from a spouse not with a retaliatory strike, but with a factual, emotionless statement that is designed for a judge to read 6 months later. This is the strategic utility of the divorce university. It trains you to play the long game while your opponent is playing for the moment. The 2026 documentaries also dive deep into the parenting plan architecture. This is perhaps the most transformative part of the curriculum. Instead of a generic custody schedule, the university provides a masterclass in child development and the logistics of the modern American family. Case studies show parents in high-stakes careers using AI-driven scheduling modules within the university to map out holiday rotations, extracurricular transportation, and right of first refusal clauses that are tailored to their specific 2026 realities. The step-by-step process involves identifying the child's specific needs at their current developmental stage and projecting those needs 5 years into the future. By the time these parents reach mediation, they have a 30-page, comprehensive parenting plan that addresses issues the courts usually overlook, such as digital screen time limits and international travel protocols. The utility of these platforms is also found in their ability to provide a historical perspective on potential outcomes. Many users enter the divorce process with unrealistic expectations, fueled by anecdotes from friends or dramatized television shows. The Divorce University uses data from thousands of historical cases to show students the most likely outcomes for their specific situation. For example, a module might show that in a particular judicial district, judges rarely award alimony for marriages lasting less than 7 years. This piece of information alone can prevent a student from spending $50,000 in legal fees to chase an outcome that has a 2% chance of occurring. Furthermore, these documentaries highlight the step-by-step document preparation phase. In 2026, many U.S. courts have moved to fully digital filing systems. A divorce university walks a student through the e-filing process, showing them exactly where to upload a decree of dissolution, how to format a motion for temporary orders, and how to serve papers in compliance with local statutes. The level of detail is granular: which button to click, which file format to use, and how to verify that the clerk has accepted the filing. This removes the mystery and the fear of the administrative process. As we analyze the footage from these investigative series, we see that the real power of the divorce university is the preservation of mental bandwidth. When you know what is coming next, your anxiety levels drop. When you understand the math, your fear of poverty subsides. When you have a communication script, you stop engaging in toxic loops. This masterclass in the utility of online divorce education shows that we are moving toward a more rational, less adversarial way of ending partnerships. But there is a secret weapon that these universities use to ensure their students stay 5 steps ahead of the traditional legal machine. There is a specific module that focuses on the tactical use of mediation as a weapon of efficiency, rather than just a suggestion from the court. In the next part of this deep dive, we are going to explore the high-stakes world of strategic mediation and the specific tactics taught in these universities to bypass the courtroom entirely. We will look at how 2026 technology is being used to conduct virtual mediations that are more effective than any face-to-face meeting ever was. We will also reveal the one document that most people forget to prepare, which often leads to the total collapse of a settlement at the 11th hour. Stay with us as we uncover the secrets of the Divorce University's most advanced tactical modules. The tactical center of any modern divorce university is the module on strategic mediation. In the 2026 documentary series The Settlement Syndicate, viewers are shown a starkly different version of mediation than the one that existed a decade ago. It is no longer portrayed as a soft, emotional sit-down where parties try to make nice. Instead, it is framed as a high-stakes corporate negotiation where the primary objective is the mitigation of legal risk and the preservation of capital. This is the utility that makes online platforms so valuable. They teach you how to treat your own divorce as a business merger that is currently being unwound. Consider the case study of Julian, a lead software architect in Seattle, featured in the 2026 documentary Protocol of Parting. Julian's situation was complex, involving restricted stock units, a shared mortgage on a high-value property, and a significant cryptocurrency portfolio that had fluctuated wildly throughout 2025 and into 2026. Traditional litigation would have likely required a court-appointed expert to value these assets, a process that can take months and cost tens of thousands of dollars. Instead, Julian enrolled in a divorce university's strategic negotiation track. The first thing the university taught Julian was the concept of the narrative frame. Historical trends show that the party who controls the narrative of why they are in mediation often dictates the pace of the settlement. Julian didn't walk into the virtual mediation room with a list of grievances. Following the step-by-step details of his online curriculum, he arrived with a preloaded digital dashboard. This dashboard, a tool provided by the university, used real-time API feeds to show the current market value of every shared asset. Imagine the power of being able to shift a negotiation from "I think this is worth X" to "here is the live market data from 3 independent sources that proves the value is Y." The technology portrayed in these 2026 documentaries is a far cry from the grainy Zoom calls of the early 2020s. We see Julian using a virtual mediation suite where an AI-driven moderator assists the human mediator. This AI analyzes the sentiment of the language being used in real time. If the negotiation starts to lean into high-conflict vocabulary that historically leads to a stalemate, the system flags it and suggests more neutral, objective phrasing. Julian was trained by his online university to recognize these flags and pivot back to the data. This is what documentaries call the professionalization of the parting. By the end of a 6-hour session, Julian and his spouse had reached a tentative agreement that would have taken a year in the traditional court system. However, as many documentaries highlight, reaching an agreement is only half the battle. This brings us to the specific document that most people forget to prepare, which often leads to the total collapse of a settlement at the 11th hour. The Implementation and Transfer Protocol, or ITP. Most people leave a mediation session with a memorandum of understanding, a general outline of who gets what. But they fail to specify the how, the when, and the who is responsible for the fees. In the documentary The Final Signature, we see a case study of a couple in Austin, Texas, who agreed to split a retirement account 50-50. They shook hands, the mediator filed the paperwork, and they thought they were done. But because they didn't have an ITP, they didn't specify who would pay for the Qualified Domestic Relations Order, or QDRO, which is the legal document required to actually move the money without tax penalties. 6 months later, they were back in court, spending another $5,000 in legal fees to argue over a $300 filing fee. A divorce university provides a step-by-step blueprint for the ITP. It forces the student to answer the granular questions before the mediation ends. If the house is being sold, who is the specific realtor? What is the exact date it must be listed? If a car is being transferred, who pays the registration fees for the current year? By addressing these micro-logistics during the mediation, the student ensures that the settlement is not just an idea, but an executable contract. Documentaries portray this as the difference between a clean break and a lingering legal nightmare. Let's look at the historical trends of mediation success rates when one party is digitally educated versus when both are flying blind. Data from 2024 to 2026 suggests that settlements reached through mediated education have a 40% lower rate of post-decree litigation. This means that once the papers are signed, they stay signed. The utility of the online university here is in creating a durable agreement. The university's curriculum also dives into the tactical use of the walk-away point. In a high-stakes scenario, emotions can lead a person to agree to terms that are unsustainable just to get the process over with. The university's financial modeling tools allow a student like Julian to run simulations of his life 5 years into the future, based on different settlement scenarios. Imagine if you could see in a 2031 projection that giving up the house today in exchange for keeping your full pension would result in a 20% higher net worth by retirement. This kind of data-driven foresight is what the 2026 documentaries are calling the new literacy of the American middle class. The step-by-step preparation for this level of mediation involves 3 distinct phases taught in the online modules. Phase 1 is the information scour, where every receipt, every account, and every asset is indexed and verified. Phase 2 is the option generation, where the student creates at least 3 different settlement structures: a target, a fallback, and a walk-away. Phase 3 is the simulation, where the university's AI bots play the role of a high-conflict spouse or a difficult attorney, allowing the student to practice staying calm and focused on the numbers. In the 2026 documentary landscape, these online universities are not just seen as educational platforms, they are seen as a form of insurance. They insure the individual against the chaos of the legal system and the unpredictability of human emotion. We are seeing a move toward what experts call the modular divorce, where the legal decree is simply the final administrative stamp on a process that was largely handled through sophisticated digital education and strategic planning. But as we peel back the layers of these documentaries, we find that the most significant utility isn't just in how the divorce ends, but in how the individual is prepared for the day after. Many people focus so heavily on the battle that they forget to plan for the peace. There is a specific, often overlooked module in these universities that focuses on the immediate financial and credit restructuring that must happen within the first 48 hours of a filing. In the next part of our deep dive, we are going to look at the 2026 methods for credit shielding and financial identity protection. We will examine the case studies of individuals who saved their credit scores from total destruction by following a specific digital checklist. We will also look at how documentaries are portraying the rise of the divorce insurance policy, a new financial product that is changing how Americans view the risk of marriage. Stay with us as we move into the mechanics of the financial afterlife of a 2026 divorce. The moment a petition is filed, a silent timer begins in the American financial system, and if you are not prepared, your credit score can become the first casualty of your marital dissolution. In the 2026 documentary The Financial Severance, we are introduced to the concept of the credit shield, a cornerstone module of the divorce university curriculum. To understand the utility of this, we must look at the case study of Elena, a 42-year-old nurse practitioner in Miami. When Elena decided to file for divorce in early 2026, she didn't realize that her joint credit card with her husband had a $50,000 limit. Within 48 hours of the filing, her spouse, acting out of emotional distress, maximized that limit on non-essential luxury items and travel. Under traditional circumstances, Elena would have been legally tethered to that debt until a judge ruled otherwise, a process that could take over a year. However, Elena had completed the credit shielding and financial identity protection module. Step 1 of this protocol involves the immediate issuance of a notice of non-responsibility to every creditor associated with the joint account. The university provides students with specific templates that cite relevant state statutes regarding the freezing of credit lines during a pending dissolution. Elena followed the university's step-by-step detail. She contacted the Big 3 credit bureaus to place a security freeze on her individual profile, ensuring no new joint accounts could be opened without her biometric 2026 standard verification. She then moved to Step 2, which is the creation of a financial lifeboat. This involves opening a solo checking and savings account at a completely different financial institution than the one used for the marital accounts. This prevents the common issue of cross-collateralization, where a bank might seize funds from a personal account to cover a default on a joint loan. Imagine if you woke up to find your digital identity had been compromised by the person who knows your passwords better than anyone else. Documentaries like Privacy and Pieces highlight that in 2026, digital domestic abuse often takes the form of financial lockout. The Divorce University teaches a comprehensive digital fortress protocol. This isn't just about changing passwords. It is about a systematic audit of every 2FA device, every shared cloud storage folder, and every automated payment system. Elena was taught to use a high-security password manager to generate unique, 20-character strings for every financial portal, and to revoke access to any shared devices that might still be logged into her personal email. This level of preparation ensures that the information asymmetry we discussed earlier doesn't turn into a total financial blackout. Historical trends show that individuals who do not perform this digital triage within the first 48 hours of a separation are 60% more likely to experience unauthorized withdrawals or identity-related interference. The utility of the online university here is providing a checklist that is updated for 2020 SIXS biometric and AI-integrated banking systems. For instance, Elena was instructed to update her voice recognition and facial ID profiles, as her spouse had previously been able to bypass older security measures. Beyond immediate defense, these documentaries are now portraying a groundbreaking shift in American risk management: the rise of divorce insurance, often referred to as marital hazard mitigation. In the 2026 investigative piece Hedging the Heart, filmmakers explore how these new financial products are being integrated into the divorce university curriculum. Imagine a scenario where you pay a monthly premium during your marriage, similar to a disability or life insurance policy. If the marriage ends, the policy triggers a payout designed to cover the high costs of legal retainers, relocation, and the temporary loss of a second income. The documentary features a case study of a couple, David and Chloe, who took out a divorce insurance policy 3 years prior to their split. When they enrolled in the university to manage their dissolution, they discovered that their policy provided a $50,000 liquidity bridge. This meant they didn't have to fight over who would stay in the house while the case was pending. The insurance covered Chloe's first 6 months of rent in a new apartment and her initial retainer for a mediator. This financial cushion fundamentally changed the power dynamic of the negotiation. Because neither party was desperate for immediate cash, they were able to make more rational, long-term decisions regarding their assets. The Divorce University teaches students how to evaluate these policies, how to file claims effectively, and how to use the payout as leverage to reach a settlement faster. Then there is the critical utility of tax-efficient uncoupling. Historical trends in U.S. tax law, particularly as we look at the 2026 landscape, have made the division of assets a minefield. The Divorce University includes a deep dive tax shield module that focuses on Section 1041 of the Internal Revenue Code. This section allows for the transfer of property between spouses or former spouses incident to a divorce without the immediate recognition of gain or loss. However, many people fail to understand the hidden tax liabilities inside certain assets. Consider an imaginative scenario. You are offered the choice between $100,000 in a savings account or $100,000 in a 401k. To the untrained eye, they look equal. But the university teaches you to look at the after-tax value. The documentary The Hidden Percentage follows a student who realized that by taking the savings account, they were receiving a dollar-for-dollar value, whereas taking the 401k would result in a 20% to 30% tax hit upon withdrawal. The university provides a step-by-step calculator where students input their current tax bracket and the projected tax rates for 2026 to see the true value of every asset on the table. This level of detail allows for a truly equitable distribution, rather than one that just looks fair on paper. As we look closer at the footage from these 2026 documentaries, we see that the utility of these platforms extends into the actual physical transition of the household. There are modules dedicated to the valuation of tangible assets, using AI-driven appraisal tools that can scan a room and provide a 2026 market value for furniture, electronics, and collectibles. This prevents the common and costly mistake of paying attorneys $300 an hour to argue over a $200 television. By automating the appraisal process, the university allows students to create a comprehensive inventory that is ready for a mediator's review in a fraction of the time. The data-driven approach of the Divorce University is changing the narrative from one of loss to one of strategic restructuring. It prepares the student for the day after the divorce is finalized, ensuring they have a restored credit score, a secure digital identity, and a tax-minimized asset base. But even with the most sophisticated financial plan, there is one variable that can destroy everything: a high-conflict personality who refuses to follow the logic of the numbers. In the next part of this masterclass, we are going to explore the high-conflict personality protocols taught by these universities. We will look at how documentaries are portraying the use of forensic psychology to manage a spouse who is determined to win at all costs. We will also reveal the 2026 technology used to document and neutralize parental alienation in real time. Stay with us as we move from the financial battlefield into the psychological arena of the modern American divorce. The transition from the financial fallout to the psychological battlefield is where most unrepresented litigants lose their footing. In the 2026 documentary series Mind Games in the Mockery, investigative journalists explore how the legal system is often weaponized by what psychologists call high-conflict personalities, or HCPs. These are individuals who do not seek a resolution. They seek a victory that involves the total destruction of their former partner. For the average person, being on the receiving end of this is like fighting a wildfire with a garden hose. This is where the psychological utility of a divorce university becomes a strategic necessity, rather than an elective. In 2026, these online platforms have integrated modules on forensic psychology that were once reserved for top-tier legal teams. They teach students how to identify the 4 key behaviors of an HCP: a preoccupation with blaming others, all-or-nothing thinking, unmanaged emotions, and extreme behaviors. Imagine if you were Alex, a graphic designer in Denver, whose spouse has spent the last 6 months sending 300 text messages a day, each one a calculated strike designed to provoke a reaction that can be used as evidence of instability. In a traditional scenario, Alex might respond in anger, providing his spouse with the exact ammunition needed for a restraining order or a custody challenge. However, Alex's enrollment in a divorce university provided him with the high-conflict personality protocol. The first step-by-step detail taught in this module is the digital gray rock method. This isn't just about ignoring the person. It's about becoming as uninteresting and non-responsive as a gray rock. The university provides a software interface that integrates with Alex's communication apps. This 2026 standard AI tool scans incoming messages and filters out the emotional bait, presenting Alex with only the logistical facts. If a message says "You are a pathetic father and I hope you rot, but also the kids need to be picked up at 5, the AI strips away the vitriol and presents a simple notification: pick up children at 5 p.m. This leads into the tactical utility of the BIF response, which we touched on earlier but which documentaries like The Custody Code expand upon in exhaustive detail. BIF stands for brief, informative, friendly, and firm. The university doesn't just explain the acronym. It provides a sandbox environment where Alex can practice writing responses. The historical trends in 2026 family courts show a dramatic shift toward judges favoring the parent who remains a professional communicator. Case studies highlighted in recent films show that when one parent consistently uses BIF responses while the other parent continues a pattern of high-conflict haranguing, the court begins to view the latter as a litigation abuser. Now let's look at the most harrowing part of the psychological arena: parental alienation. In the 2026 documentary The Alienation Archive, filmmakers follow parents who have been systematically erased from their children's lives through psychological manipulation by the other parent. The utility of the divorce university in this context is the teaching of the 5-factor model of alienation. This is a scientific framework used by forensic psychologists to determine if a child's rejection of a parent is justified or the result of a campaign of denigration. The university teaches a student like Jordan, a teacher in Chicago, how to document these 5 factors in real time. Factor 1 is the presence of a prior positive relationship. Factor 2 is the absence of abuse. Factor 3 is the use of alienation behaviors by the other parent. Factor 4 is the child's display of the 8 behavioral manifestations of alienation. Factor 5 is the lack of a balanced view of both parents. The step-by-step instruction involves Jordan maintaining a digital log of alienation. Imagine if Jordan's children suddenly start using adult language to describe legal issues, or if they refuse to visit because of vague, non-specific fears that mirror the other parent's complaints. The university's platform provides Jordan with a template to record these incidents objectively. Instead of writing "My ex is brainwashing my kids," which a judge will dismiss as hearsay, Jordan is taught to write on Tuesday, June 12th, the child used the phrase fiduciary negligence to explain why they did not want to attend dinner, a term not consistent with their developmental age but frequently used in the other parent's recent legal filings. This data-driven documentation is what changes potential outcomes in a 2026 custody hearing. Furthermore, the 2026 technology portrayed in these documentaries includes the use of predictive litigation tools. These are AI systems that analyze the writing style and filing history of an opposing party's attorney. If the university's database identifies that the opposing counsel has a historical trend of filing emergency motions on Friday afternoons to disrupt weekend visitation, the student is taught the preemptive defense module. This involves preparing a draft response for a specific motion before it is even filed. When the motion eventually hits the court's digital portal, the student can respond within minutes, demonstrating a level of preparedness that often catches high-conflict litigants off guard. The utility of these platforms also extends to the student's own mental health. Documentaries often feature the psychological audit, a self-assessment tool that helps the student identify their own triggers. If you are being baited into a fight, the university's wearable tech integration can monitor your heart rate and cortisol levels. In 2026, some advanced students use smartwatches that vibrate when the AI detects they are drafting a response while in a state of high physiological arousal. The university's instruction is simple: never hit send when your heart rate is above 90 beats per minute. We are seeing a move toward what sociologists call the emotional professionalization of the American family. The divorce university treats the end of a marriage as a project that requires a high level of emotional intelligence. Case studies from the documentary The EQ Decree show that parents who score higher on the university's EQ assessments are 50% more likely to secure the parenting time they requested. This is because they appear stable, predictable, and child-focused in a system that is weary of parental drama. The depth of this curriculum is staggering. There are modules on how to prepare children for the transition using age-appropriate scripts, how to handle the first holiday alone, and how to de-escalate a physical confrontation in a public exchange location. The utility is found in the reduction of chaos. By replacing raw emotion with the structured curriculum, the divorce university creates a buffer zone between the student and the conflict. As we analyze the 2026 media coverage, it becomes clear that the psychological theater of divorce is no longer a place where the loudest voice wins. It is a place where the best documented, most emotionally regulated person thrives. But even with a perfect psychological defense and a rock-solid financial shield, there is a hidden danger lurking in the digital shadows. Most people in 2026 don't realize that their own past digital footprints are being mined by high-tech firms to build a profile of their character that can be used against them. In the next part of this deep dive, we are going to explore the world of digital forensic mining. We will look at how documentaries are portraying the use of deleted social media posts, old location data, and even smart home recordings in the modern courtroom. We will reveal the 2026 step-by-step protocol for a digital privacy scour, the only way to protect your past from destroying your future. Stay with us as we uncover the secrets of the shadow files. In the world of 2026 litigation, your digital ghost is often more talkative than you are. Documentaries like The Ghost in the Machine, Digital Divorce have begun to expose a terrifying new reality. Every smart device, every archived social media post, and every byte of metadata is a potential witness in your dissolution case. The utility of an online divorce university in this landscape is not just about filing forms. It is about conducting a comprehensive digital privacy scour before your own history is weaponized against you. In 2026, the traditional legal discovery process has been replaced by AI-driven forensic mining that can reconstruct your entire life from a handful of cloud backups. Consider the case study of Taylor, a 38-year-old systems architect in Austin, Texas. Taylor was navigating a relatively amicable separation until the issue of primary residency for his 2 children arose. Taylor's spouse hired a forensic firm that utilized a 2026 standard AI mining tool. This tool didn't just look at Taylor's recent texts. It scraped his location history from a forgotten fitness tracking app he hadn't used in 3 years. By cross-referencing GPS pings with local business registries, the firm attempted to build a narrative that Taylor spent an excessive amount of time at a local sports bar during his previous weekends with the children. If Taylor hadn't been enrolled in a divorce university, he would have been blindsided in mediation. However, his curriculum included a module titled The Shadow Files, Digital Audit and Forensic Defense. Following the step-by-step details of the university's protocol, Taylor had already performed a digital privacy scour 3 months prior. Step 1 of this protocol is the centralized account audit. The university provides a tool that identifies every third-party application linked to your primary email and phone number. Taylor discovered 142 apps he had forgotten about, ranging from old dating profiles to loyalty programs and, most importantly, that fitness tracker. The university's instruction here is critical and follows strict legal compliance. Do not delete. In the 2026 legal environment, the wholesale deletion of digital accounts after a divorce filing can be flagged as spoliation of evidence, a serious offense that can lead to adverse inferences by a judge. Instead, the university teaches the archive and authenticate method. Taylor was taught to download the full data packets from these apps, a legal right under various U.S. privacy laws, and store them in an encrypted vault. This allowed him to see exactly what his spouse's forensic team would see. When the bar-hopping narrative was presented, Taylor's own data packet proved that he was actually at a grocery store and a park located in the same commercial complex as the bar. The GPS ping was identical, but the transaction receipts he had archived via his university checklist provided the context that dismantled the accusation. Step 2 of the digital privacy scour involves metadata management. Imagine if a photo you sent to your spouse to show you were home with the kids actually proved you were somewhere else. Every photo taken on a 2026 smartphone contains EXIF data, exchangeable image file format. This data includes the exact GPS coordinates, the altitude, the device name, and the millisecond the shutter was pressed. A common documentary highlight shows how litigants use this data to prove a spouse was violating a temporary restraining order or a travel restriction. The Divorce University teaches students how to use metadata scrubbers for all future communications, ensuring that while the content of the photo is shared, the sensitive background data is neutralized. Next, we look at the step-by-step IoT audit. In 2026, the American home is a network of snitches. Smart thermostats, doorbell cameras, and even AI-integrated refrigerators track your movements and habits. Documentaries like Domestic Intelligence portray cases where smart home logs were subpoenaed to prove a party was not residing in the marital home as claimed, or to show that an unauthorized individual was staying overnight in violation of a morality clause. The Divorce University provides a specific 2026 checklist for the Internet of Things. Taylor followed this checklist to audit his Ring camera and Nest thermostat. He discovered that his spouse still had administrative access to the accounts, allowing her to monitor his comings and goings in real time. The university's protocol for this is the administrative reset. It teaches you how to legally revoke shared access and change the primary credentials, provided it does not interfere with the other party's court-ordered access to the property. This prevents the digital stalking that has become a hallmark of 2026 high-conflict divorces. The utility here extends into the realm of historical trends in social media evidence. Data from 2025 and 2026 suggests that over 80% of divorce cases now involve evidence pulled from social platforms. This isn't just about a controversial post. It's about the context of likes, tags, and even the background of your friends' stories. The Divorce University teaches the social media sanitization protocol. This is a 5-step process. First, set all accounts to the highest privacy level. Second, audit all tagged photos from the last 5 years. Third, disable location tagging on all future posts. Fourth, inform your social circle in writing to refrain from tagging you in any content. Fifth, and most importantly, treat every direct message as a potential court exhibit. Imagine if your spouse's attorney uses a photo of you at a wedding from 2019 to argue that you have a history of substance abuse because you are holding a glass of champagne. This is a common tactic in 2026. The university teaches you how to build a narrative buffer. You don't hide the past. You contextualize it. Taylor was taught to write a digital statement of context for his most visible social media history, explaining the events in a way that aligns with his current character profile. The depth of this digital defense module is what separates a divorce university from a simple legal blog. It addresses the 2026 reality of deepfakes and AI-generated misinformation. Documentaries are now showing how some litigants attempt to use AI to forge incriminating text messages or even audio clips. The university teaches students how to use digital watermarking and blockchain-verified communication tools to ensure that every message they send is authenticated and tamper-proof. This is the ultimate defensive utility. When you can prove that your digital trail is unalterable, you eliminate the possibility of fraudulent evidence being used against you. As we conclude this exploration of the digital privacy scour, it is clear that the modern U.S. documentary is portraying a world where the most prepared person is the one who has mastered their own data. But even with a sanitized digital life, there is one final hurdle that every student of the Divorce University must clear. It is the moment when the theory of the online modules meets the cold reality of the judicial system. In the next part of this deep dive, we are going to look at the courtroom simulation and judicial profiling modules. We will examine how 2026 technology allows students to practice their testimony against an AI that mimics the specific temperament of their assigned judge. We will also reveal the historical trends of how judges are reacting to the rise of the educated pro-se litigant. Stay with us as we step inside the virtual courtroom of the future. The virtual courtroom of 2026 is no longer a futuristic concept found in science fiction. It is the default setting for the majority of family law proceedings across the United States. In the landmark 2026 documentary The Digital Bench, we see a profound shift in how the average American prepares for their day in front of a judge. This is where the Divorce University's most sophisticated module, the Courtroom Simulation and Judicial Profiling Engine, provides a level of utility that was previously accessible only to the wealthiest 1% who could afford high-priced consultants and jury researchers. Imagine if you were Maya, a 35-year-old freelance interior designer in Atlanta, Georgia. Maya is facing a complex hearing regarding the valuation of her business and the subsequent calculation of spousal support. Her former partner has hired a traditional law firm known for its aggressive litigation tactics. In a 2020 scenario, Maya would have walked into that hearing with nothing but her own notes and a high level of anxiety. In 2026, Maya enters her virtual hearing after 40 hours of immersive simulation. The first step-by-step detail of the judicial profiling module is the data ingestion phase. The Divorce University's AI analyzes every publicly available ruling, transcript, and judicial opinion authored by Maya's specific presiding official, Judge Harrison, over the last 8 years. Historical trends show that judges, being human, have specific patterns and preferences. The AI identifies that Judge Harrison has a high affinity for organized, chronologically indexed digital exhibits and a low tolerance for emotional testimony that lacks a direct tie to statutory factors. Following the university's protocol, Maya doesn't just read about Judge Harrison, she interacts with him. The university uses advanced voice synthesis and generative AI to create a high-fidelity simulation of the judge. Maya puts on her VR headset and enters a digital recreation of the Fulton County Superior Court. The simulated Judge Harrison asks her the same difficult questions he has asked in similar cases involving business valuation. When Maya's voice rises in pitch or she begins to use filler words like or the simulation pauses. An on-screen coach provides real-time feedback. Maya, your vocal frequency suggests high stress, which the judge may interpret as a lack of confidence in your data. Lower your register and stick to the profit and loss statement from 2025. This level of detail is what documentaries call the competency bump. Data from 2026 court efficiency reports suggest that pro-SE litigants who have completed a structured online curriculum are 45% more likely to have their motions granted compared to those who have not. This isn't because of a bias toward the university. It is because these litigants have mastered the rules of evidence and the specific procedural protocols of their jurisdiction. Step 2 of the preparation involves the exhibit indexing and e-filing mastery module. In 2026, many U.S. courts utilize a blockchain-verified filing system to ensure document integrity. The Divorce University teaches Maya exactly how to format her digital binder so that it is perfectly compatible with Judge Harrison's preferred viewing software. Imagine the psychological advantage Maya gains when the judge opens her file and finds a flawlessly hyperlinked table of contents, allowing him to jump from a summary of assets directly to the underlying bank statement with a single click. Documentaries portray this as the professionalization of the pro-SE litigant, where the individual is effectively outperforming the junior associates of the opposing law firm. Now, let's look at the historical trends of how judges themselves are reacting to this rise of the educated litigant. In the investigative piece Justice 4.0, several U.S. judges are interviewed anonymously. They reveal a surprising trend. They often prefer dealing with university-trained litigants over traditional attorneys. The reason is efficiency. A graduate of a divorce university is trained to be concise, to cite the specific sections of the state code, and to avoid the theatrical bickering that often bogs down a courtroom. These judges report that hearings which used to take 3 hours can now be completed in 45 minutes, when the parties are utilizing the university's strategic communication templates. The simulation also includes a cross-examination drill. Maya's AI-driven simulation doesn't just play the part of the judge, it also plays the part of the opposing counsel. It uses the specific rhetorical style of her spouse's attorney, which the university has indexed from their previous public cases. Maya is peppered with aggressive questions about her business expenses. She is taught the step-by-step detail of the pause and pivot technique. When asked a loaded question designed to make her defensive, Maya is trained to pause for 2 seconds, allowing her to regulate her nervous system, and then pivot back to the objective data. The documentary footage shows a side-by-side comparison of a raw, untrained litigant and a university graduate. The untrained individual is often seen looking at the camera with wide eyes, stumbling over their words, and eventually breaking down in frustration. The university graduate, however, maintains a professional, neutral expression, looks directly into the lens of their webcam to simulate eye contact with the judge, and provides answers that are structured like a legal brief. This is the utility of the divorce university in the arena of human perception. Furthermore, the 2026 technology allows for biometric calibration. During her practice sessions, Maya wears a smartwatch that syncs with the university's software. It tracks her heart rate, skin conductance, and respiratory rate. If Maya's heart rate spikes to 110 beats per minute during a specific line of questioning about her parenting, the software flags this as a vulnerability zone. It then provides her with additional modules on emotional regulation and cognitive reframing, specifically for that topic. By the time the actual hearing occurs, Maya has been desensitized to the emotional triggers that her opponent was planning to exploit. The final phase of the courtroom utility is the post-hearing protocol. The university teaches students how to listen for the specific phrasing in a judge's oral ruling, and how to immediately draft a proposed order that accurately reflects that ruling. In 2026, the speed of the court is dictated by the speed of the paperwork. By being the first to submit a high-quality proposed order, the student often defines the final language of their own decree. As we analyze the impact of these simulations, we see that the divorce university is effectively closing the gap between the law as it is written and the law as it is practiced. It removes the mystery of the courtroom and replaces it with a repeatable, data-driven process. It empowers people like Maya to stand their ground in a system that was historically designed to be navigated only by professionals. However, as many documentaries are now starting to warn, winning in the courtroom is only the beginning of the end. There is a whole other world of administrative complexity that follows the judge's signature. Many people believe that once the decree is signed, the struggle is over. But in 2026, the actual transfer of assets, the restructuring of retirement accounts, and the enforcement of support orders can be just as treacherous as the litigation itself. In the next part of this deep dive, we are going to explore the high-stakes world of post-decree asset migration and enforcement. We will look at the 2026 case studies of individuals who won their cases but lost their settlements because they didn't understand the mechanics of the QDRO or the interstate enforcement of support. We will also reveal the university's step-by-step checklist for the first 30 days after the judge's final signature, the period known in the documentary world as the execution gap. Stay with us as we uncover the secrets of actually getting what you were awarded. The judge has struck the gavel, the final signature is digitized on the court's portal, and for a brief moment, you feel the weight of the world lift. But in the 2026 documentary Paper Victories, filmmakers reveal a cold, hard truth. For many Americans, the most dangerous phase of the entire process is just beginning. This is what the divorce university calls the execution gap. It is the high-stakes period between being awarded an asset on paper and actually having that asset securely in your possession. Historical trends suggest that nearly 30% of awarded assets are never properly transferred, or they are significantly diminished in value because the winning party did not understand the post-decree mechanics. This part of our masterclass is about the technical utility of the university's 30-day sprint protocol, a step-by-step system for closing that gap before the window of opportunity slams shut. Imagine if you were Robert, a 50-year-old project manager in Chicago. Robert was awarded exactly $450,000 from his former spouse's 401k account. In a traditional scenario, Robert might have waited for his ex-spouse or her attorney to initiate the transfer. That is a mistake that costs thousands in potential market growth and tax liabilities. Instead, the Divorce University curriculum taught Robert the step-by-step detail of the Qualified Domestic Relations Order, or QDRO. This is a specialized legal instrument that allows a retirement plan to pay a portion of an account to an alternate payee without triggering the 10% early withdrawal penalty. But here is the catch. Every plan administrator in the United States, from massive firms like Fidelity to smaller boutique pension funds, has their own specific model language and 2026 compliance protocols. If your QDRO does not match their internal requirements to the letter, they will reject it, and you will be sent back to the end of a very long administrative line. The university provided Robert with a database of these specific plan requirements. He did not just guess. He used a pre-vetted template tailored to his spouse's specific employer. He was taught to contact the plan administrator immediately to place a hold on the account, ensuring no loans or withdrawals could be taken while the QDRO was being processed. This is the utility of preparation. Robert had his funds transferred into a separate IRA in his own name within 45 days, whereas the average uneducated litigant often waits over 6 months, during which time the account holder could have borrowed against the balance or market volatility could have eroded the total. Now, imagine if the house was awarded to you but the mortgage and the title are still in both names. This is where the 2026 documentary, The Title Trap, finds its most heartbreaking case studies. Imagine a character named Maria in Phoenix. The court gave her the family home, but her ex-spouse refused to sign the quitclaim deed. The university curriculum teaches the step-by-step process of the clerk's deed, or the Ellis Electronic Legal Instrument System, in jurisdictions that have adopted 2026 blockchain-verified recording. Maria was taught that if her ex-spouse refused to sign, she could file a motion for the clerk of the court to sign on their behalf. But more importantly, the university provided her with a checklist for the mortgage. Just because you have the house does not mean you have the loan. Maria followed the university's step-by-step refinance bridge protocol, allowing her to assume the mortgage or secure a new 2026 interest rate before her ex-spouse's potential credit issues could jeopardize the property title. We must also discuss the utility of the State Disbursement Unit, or SDU. In the documentary Enforcement 2026, we see the case study of Sarah, a mother in Florida who was awarded $2,000 a month in child support. Her ex-spouse promised to send the money via a digital payment app to keep things simple. The university warned her against this. Historical trends show that private, off-book payments are the primary source of post-decree litigation because there is no state-verified record of payment. The university taught Sarah how to register her order with the Florida SDU immediately. This triggered an income withholding order, or IWO, which deducted the support directly from her ex-spouse's paycheck. This removes the emotion, removes the need for monthly awkward conversations, and ensures that the state is the official bookkeeper. If a payment is missed, the state's 2026 automated systems trigger enforcement actions, such as driver's license suspension or tax refund interception, without Sarah having to pay an attorney another dime for a contempt of court filing. Beyond the big-ticket items, the Divorce University focuses on the granular details of the first 30 days that most people overlook. This includes the life insurance beneficiary audit. Imagine if 2 years after your divorce you pass away, and your life insurance payout goes to your ex-spouse because you forgot to update a single form at your HR office. This is a common historical trend that leads to massive family legal battles. The university provides a 2026 digital admin sweep checklist. This includes updating emergency contacts, changing the beneficiaries on every investment account, and, crucially for those in marriages lasting over a decade, filing for the Social Security 10-year rule. If you were married for over 10 years, the university teaches you how to claim a portion of your ex-spouse's Social Security benefits without reducing their own benefit. Most people have no idea this exists, yet it can mean thousands of dollars in annual income during retirement. Finally, let's look at the case of Marcus in Silicon Valley. His 2026 divorce involved a significant amount of cryptocurrency and shared digital storage. The university's digital migration module taught him how to use multi-signature wallets to ensure that the division of Bitcoin and Ethereum was transparent and immutable. It also taught him how to perform a cloud divorce, splitting a shared family cloud account so that private data was migrated to a new, secure ID without losing years of digital photos and documents. This is the 2026 utility that traditional law firms are still struggling to understand. The Divorce University does not just get you to the finish line. It ensures you stay there. By treating the first 30 days as a technical project rather than an emotional aftermath, students are able to secure their financial and digital future with precision. But even with the assets transferred and the support automated, a new question emerges for the American public in 2026. How do you re-enter the workforce, the dating market, and the social scene as a transformed individual? There is a final secret module in these universities that focuses on the career and social rebranding of the divorced professional, a strategy that is currently doubling the income of some graduates. In the next part of this deep dive, we are going to explore the high-impact professional reentry protocol. We will look at how documentaries are portraying the massive career surges of those who have completed their divorce university education. We will also reveal the 2026 trends in the divorce dating market and how AI-driven social auditing is helping people find compatible partners while avoiding the mistakes of the past. Stay with us as we uncover how to turn the end of a marriage into the ultimate professional and personal launchpad. The concept of the divorce surge is perhaps the most surprising phenomenon captured in 2026 documentaries like the Phoenix Protocol. While society has historically viewed the end of a marriage as a period of professional decline or stagnation, the data emerging from 2026 career analytics paints a different picture for those who have utilized a divorce university curriculum. We are seeing a historical trend where individuals, particularly those who have been out of the workforce or in stagnant roles, experience a significant professional pivot that results in higher income brackets and leadership positions. This is not a coincidence. It is the result of the high-impact professional reentry protocol, a module designed to translate the project management skills learned during a divorce into corporate capital. Consider the case study of Jennifer, a 44-year-old resident of Charlotte, North Carolina. Jennifer had spent the last 12 years as a stay-at-home parent, managing a complex household but possessing a resume that looked like a ghost town to 2026 AI recruiters. In a traditional 2020 landscape, Jennifer might have settled for an entry-level administrative role. However, through her divorce university education, she followed a step-by-step detail for the skills translation audit. This process involves using AI-driven software to map the logistical, financial, and legal tasks she performed during her divorce onto a corporate competency framework. Jennifer realized that managing a contested property division, coordinating with 3 different expert witnesses, and navigating a 6-figure budget was not just personal admin. It was high-level operations and risk management. The university taught Jennifer how to utilize the 2026 LinkedIn optimization techniques. In the current job market, recruiters use algorithmic filters that look for specific resilience markers and project-based certifications. Jennifer didn't hide her gap. She branded it as a period of intensive legal and financial management. Imagine if you could walk into an interview and explain how you successfully mediated a multi-asset dissolution using data-driven negotiation tactics. To a 2026 hiring manager, that demonstrates a level of emotional intelligence and professional grit that a standard business degree cannot convey. Jennifer secured a role as an operations director for a regional tech firm within 4 months of her decree, a potential outcome that the documentary credits entirely to her modular education. The utility of the professional reentry module also extends to the entrepreneurial launchpad. Documentaries are portraying a rise in what is called the silver startup, businesses founded by individuals immediately following a divorce. Because the university has already taught these students how to manage contracts, audit finances, and protect intellectual property, they possess the foundational knowledge of a business owner before they even file for an LLC. We see case studies of individuals using their settled assets as seed capital, managed through the 2026 Standard Lean Divorce methodology, which emphasizes the preservation of liquidity for future investment. But the rebranding process is not just professional, it is deeply social. This leads us to the digital identity refresh, a critical step-by-step detail for re-entering the 2026 social arena. Documentaries like The Second Impression highlight how a messy digital history can sabotage a person's social and dating prospects long after the legal dust has settled. The university teaches a protocol for the social media pivot. This involves more than just deleting old wedding photos. It is a strategic rollout of a new individual brand. Students are taught to archive their past in a way that respects their history without allowing it to define their future. For example, the university provides templates for a 2026 life update post, a neutral, high-value statement that informs their social circle of the transition without inviting gossip or drama. Now, let's step into the most complex landscape of 2026, the divorce dating market. Investigative pieces like SwipeSafe have revealed that the dating world has become a data-heavy environment where your litigation history and financial health are often checked before the first date. In this environment, the divorce university graduate has a massive advantage. They utilize the compatibility matrix and the AI-driven social audit to avoid repeating the toxic patterns of their past. Imagine if you were James, a 48-year-old architect in San Francisco. James's first marriage ended because he failed to recognize the red flags of a high-conflict personality until it was too late. In 2026, the university provides James with a tool that analyzes the digital communication patterns of potential partners. By inputting anonymized text samples with consent, which is a standard 2026 dating protocol, the AI can flag linguistic markers of high-conflict behavior or emotional volatility. This isn't about judging a person. It's about a data-driven compatibility audit. James is taught to look for what the university calls the baseline of stability. Furthermore, Documentaries are highlighting the rise of the relationship contract in 2026. Informed by their divorce education, graduates are now entering new relationships with a level of transparency that was previously unheard of. They are utilizing the step-by-step cohabitation agreement modules to define financial boundaries and expectations before moving in with a new partner. This is the utility of foresight. By treating a new relationship with the same structural integrity as a business partnership, they are drastically reducing the potential for future litigation. The historical trends in 2026 show that these educated daters are 30% more likely to report high relationship satisfaction in their second unions. This is because they have completed the emotional postmortem module. This is a grueling step-by-step analysis of their previous marriage, conducted through the university's guided reflection tools. They identify their own contributions to the breakdown and use 2026 behavioral science techniques to rewire their attachment styles. They are not just looking for a new partner, they are becoming a better version of themselves. The utility of the Divorce University in 2026 is ultimately about the total optimization of the human experience after a crisis. It turns a period of loss into a period of intensive personal R&D. We see parents using their new scheduling and communication skills to create seamless multi-household families that documentaries describe as the new American vanguard. We see professionals using their legal literacy to negotiate better contracts at work. We see individuals using their financial mastery to build wealth at a pace that far exceeds their pre-divorce trajectories. But as we reach the end of this journey, there is one final question that these documentaries pose. If the Divorce University is so effective at managing the end of a marriage, what does its existence mean for the future of the institution of marriage itself? Are we moving toward a world where every marriage begins with an exit strategy? Or is this education actually the key to making marriages more durable in the first place? In the final part of this deep dive masterclass, we are going to look at the global impact and the future of matrimony. We will examine how the 2026 Divorce University model is being adapted by governments to reduce the strain on the public court system. We will also reveal the most controversial module of all, the marriage insurance protocol, which is being used by couples before they even say I do. Stay with us for the conclusion of this series as we look at how the 2026 digital revolution has forever changed the way we love, leave, and lead. The administrative burden on the United States judicial system has reached a critical tipping point in 2026, leading to what documentaries like The Verdict of the Masses are calling the Great Procedural Pivot. For decades, the family court system functioned as a bottleneck, where cases languished for years, draining the resources of both the state and the individuals involved. However, the emergence of the Divorce University as a legitimate educational tier has provided an unexpected relief valve. We are now seeing a historical trend where various state legislatures are considering, and in some cases implementing, a mandatory education credit for pro-se litigants. This shift moves the burden of procedural literacy from the court clerk to the individual, utilizing the online university as the primary delivery mechanism for this requisite knowledge. To understand the global impact of this model, we look at the case study of Brandon, a 39-year-old logistics coordinator in New Jersey. Brandon's case was selected for the 2026 documentary The Efficient Decree because it represented the first wave of what is known as the Court Integrated Education Track. In this scenario, when Brandon filed his initial petition, the court did not simply give him a hearing date, it gave him a login. Brandon was required to complete a 3-module core curriculum on the university's platform before his first appearance. This curriculum included the jurisdictional proficiency test, the asset disclosure certification, and the best interests of the child workshop. The step-by-step detail of this integration is fascinating. Each time Brandon completed a module, a digital certificate was automatically appended to his court file via a secure 2026 API. This meant that by the time Brandon stood before a judge, the court already had verification that he understood the legal standards for equitable distribution and the specific requirements for a parenting plan in his state. The utility here is staggering. The documentary reveals that in jurisdictions utilizing this integrated model, the average time from filing to final decree has dropped from 18 months to just under 6 months. This is the professionalization of the public's interaction with the law, turning a chaotic personal crisis into a structured, educational achievement. But perhaps the most controversial and revolutionary utility portrayed in 2026 media is the marriage insurance protocol. This is the proactive application of Divorce University modules before a marriage even begins. Documentaries like Before the Vows, the 2026 blueprint follow couples like Liam and Sophia, two young professionals in Seattle who decided to treat their upcoming marriage with the same level of due diligence they would apply to a corporate merger. They enrolled in a premarital version of the divorce university, not because they expected to fail, but because they wanted to build a domestic operating system that would prevent the very issues that lead to dissolution. The step-by-step process for Liam and Sophia involved a comprehensive financial transparency audit and a conflict resolution architecture. They used the university's tools to draft a living prenuptial agreement, a digital document that is updated annually to reflect their current assets, debts, and life goals. The documentary portrays this not as an unromantic calculation, but as the ultimate form of 2026 intimacy. By understanding exactly how a divorce would function, they remove the fear of the unknown, allowing them to focus entirely on the success of the partnership. Historical trends are beginning to suggest that couples who engage in this level of high-stakes educational preparation have a significantly lower rate of early marriage volatility. This leads us to the longitudinal impact on the next generation, a theme explored in the investigative series The Silent Generation 2.0. This documentary looks at the children of parents who utilize the Divorce University's child-centric digital dashboard. In 2026, we have the first datasets on kids who grew up in households where the transition was managed through educational protocols rather than adversarial litigation. The potential outcomes for these children are profoundly positive. By using the university's co-parenting modules, these parents were able to maintain a consistent narrative of respect. The data shows that these children experience lower levels of cortisol and higher academic performance compared to children in high-conflict, traditionally litigated households. The utility of the Divorce University in this context is the creation of a parallel parenting infrastructure. The step-by-step detail involves the use of a shared digital portal where all school records, medical appointments, and extracurricular schedules are managed by an AI moderator. This eliminates the need for direct, emotionally charged communication between the parents. The documentary highlights case studies where parents have not spoken a word to each other in 5 years, yet their children have experienced a seamless, high-functioning upbringing because the logistics were handled through the university's professional-grade management tools. As we look toward the future of matrimony in the United States, we see a shift away from the traditional, all-or-nothing model of marriage and toward a more modular, educated approach. The 2026 digital revolution has turned the end of a marriage into a manageable transition, but it has also turned the beginning of a marriage into a more intentional, data-driven choice. The Divorce University is no longer just a tool for those leaving a partnership. It has become a global resource library for anyone navigating the complexities of modern human relationships. The historical trends we have analyzed throughout this masterclass show that we are moving toward a world where legal and financial literacy is the new baseline for domestic life. The professionalization of the parting, the digital privacy scour, the high-conflict personality protocols, and the courtroom simulations are all components of a new American survival kit. These documentaries are portraying a society that is no longer content to be a victim of a fragmented legal system. Instead, the U.S. public is choosing to become the architects of their own transitions. The final utility of the online university is the preservation of human dignity. By providing a clear path through the darkness, these platforms allow individuals to exit a marriage with their finances intact, their reputation protected, and their mental health preserved. The 2026 landscape of divorce is not one of failure, but one of evolution. We have seen how people like Sarah, Marcus, Julian, and Elena used education to rewrite their stories. They didn't just survive their divorces, they utilized them as a catalyst for a total life upgrade. As this series concludes, we must realize that the Divorce University is just the beginning. The same logic of modular, high-stakes education is already being applied to other major life transitions, from estate planning to elder care management. The open loop we leave you with is this. In a world where every life transition can be optimized through a digital curriculum, what is the next institution to be disrupted by the power of the educated individual? The era of the expert-led life is ending, and the era of the self-taught, digitally empowered citizen has officially begun. The data is clear, the case studies are in, and the future of the American family is being written one module at a time. This has been your masterclass on the 2026 digital revolution of the heart and the law. Stay educated, stay prepared, and stay ahead of the curve.